Hello everyone, and welcome to Fieldfisher's end of the year extravaganza from the data and privacy world. My name is Hazel Grant and I am the head of data privacy based out of our London office. Thank you for joining us. Let's move on to the next slide, please. Today I'm going to be joined by a number of colleagues from mainland European offices and also our UK offices, and they're all going to introduce themselves a little bit later. For those of you who don't know us already, Fieldfisher is a European law firm with offices across Europe, in Silicon Valley and in China. Our data and privacy team works across all of those offices, and we are a collaborative team providing strategic and actionable privacy solutions. First, a little housekeeping. You can ask questions in the chat function, so keep them coming and we'll try to answer them towards the end of this session. If we don't have time, we will email you a response. Next, this session is actually slated for 1.5 hours, but we're hopeful that we can let you go a little bit earlier, depending on the number of questions. So we're aiming to finish between an hour and an hour and a quarter, so you should be finished by about 5:15 p.m. UK. So now you've seen our speakers. Let's move on to the next slide, please, and you can have a quick glance at the topics that we've chosen for this session. So, without any further ado, because we do have quite a lot to canter through in this session, I am going to hand you over to my colleague, Sarah Tedstone, and the next slide and her topic, please. Sarah, introduce yourself.
Hello, my name's Sarah Tedstone. I'm a partner in the Fieldfisher data team. And on the next slide, we will talk about UK data reform. And actually, there's a lot going on. So diving straight in, we have the UK Data Use and Access Bill, which appeared in October. So this either creates direct changes into the UK GDPR or creates powers for changes in the future. So in no particular order, the bill has changes to DSARs, so increasing time limits in certain circumstances and officially recognising that searches need only be reasonable and proportionate, and changes to the legal professional privilege exemption. There are significant changes to lawful basis. Research provisions are extensively amended, making it easier effectively to use data for research and clearer when you can do so, which has been awaited for some time. For the reuse of data, there's clarification about secondary purposes when reuse is consistent with original purposes and clarifying the position here. There's a new recognised legitimate interest legal basis where no balancing test is needed. And the examples include a list of the usual suspects, but interestingly also refers to direct marketing and the sharing of admin data amongst group companies. Special category data such as health has changes, effectively making it easier to use for research. A lot of emphasis on research in this bill, and power to add more data within the category and to add additional conditions for processing within Article 9, which will be really welcome. There's clarification of the public interest lawful basis too. For data adequacy and restricted transfers, potentially really significant changes. A power here to add further alternative transfer mechanisms, changes to Article 46 effectively, and potentially new SCCs. So there's a Christmas present for everyone, even more SCCs to work with potentially. Then PECA and cookies, we have alignment with the GDPR, effectively 72 hours for breach notifications, potentially increased fines, and for cookies, flexibility with landing cookies without consent, effectively. And next slide, thank you. With AI, we've had significant guidance from the ICO about AI, but here we're going to have complete replacement and restructuring of Article 22, the automated decision-making provisions. This will be significant and we will be monitoring this, come back and see what we will say about this ongoing. But requirement for a condition when using special category data and some safeguards still involved. Smart data, effectively widening this across many sectors. So if you think about the streamlining of the transfer of bank accounts in recent years, the idea is to apply this across many sectors, and some echoes effectively of the European Data Act here. Digital identities, we all have digital identities without really thinking about this when you apply for things, when you rent properties, etc. And there's quite a lot of provisions to enable this kind of sharing of data, but to create a framework and trusted users here. And again, similar to European provisions here. Creation of a mandatory complaints process, effectively making controllers the first point of call for any issues. The Health Service, significant practical and legal changes to improve interoperability of systems. So effectively meaning that with consistent data architecture, systems will speak to each other and there will be more access and sharing of data. Online safety researchers' access to data, amendments to the Online Safety Act here, and some echoes here to the Digital Services Act in Europe. The Information Commissioner is abolished. Instead, we get an Information Commission and significant changes to powers. Next slide, please. So what is missing from the bill that we were promised before? Well, we had been promised single unique identifiers for all data subjects. That's not yet there. A national data library improving data sets for research hasn't appeared, and we obviously have the European health data space being more advanced. We were promised binding regulation on the most powerful AI models, and we haven't yet seen that. There is obviously the comprehensive EU AI Act already in force, and we haven't yet seen a new regulatory innovation office. What was already planned that won't be affected by this? There's talk of the UK NIS2, and obviously there's the European NIS2 already in force. And we also have the first deadline for review of the EU finding of adequacy for the UK by June next year, let's not forget. Next slide, please. So what does this mean? What do we need to do? Well, you'll need to monitor changes, obviously, with what's happening, immediately in the next few months about this, and maybe more medium term with powers with future changes, and we'll be doing this. Come back and see what we have to say about this. You'll need to assess how and whether data can be used and the legal basis for processing, which may have changed. You'll need to look at how the changes to cookies will affect you, more flexibility, but what does that mean for website and app functionality? There'll be new processes and new deadlines to implement. DPIAs will be needed. You'll need to assess when regulators need to be notified about risk, and you'll probably have to respond to data subject queries about all of these changes in your business. And thank you, that's me done for UK data reform.
Thank you very much, Sarah. I'm sure there's going to be some questions on that later, so please do pop your questions in the question functionality on the panel. So next we will hand over to my colleague Kirsten. Kirsten, please introduce yourself and your topic.
Thank you, Hazel. So hello everyone, I'm Kirsten Whitfield and I'm a partner in Fieldfisher's technology and data team in London. So next slide, please. Well, 17th of October this year saw the deadline for implementing NIS2 come and go. And as it's a directive, it needed to be implemented into local law by each of the member states in the EU. So NIS2 is one law in a jigsaw of a new set of cybersecurity laws in the EU. But NIS2 is aimed at bolstering cyber resilience and protecting essential services and digital infrastructure in the EU. Now, organisations that are subject to NIS2 are going to have a range of obligations which broadly fall into the areas that I've outlined here on this slide, and I'm going to say a little bit more about that later. Next slide, please. So here at the Fieldfisher Tech and Data team, together with our fabulous network of experts at our best friend firms around Europe, have been tracking the status of implementations across Europe. And here on this screen, you'll see our most recent implementation map from 1st December. And you can see the greens here where NIS2's been implemented and the reds and ambers where it hasn't. If you want to download this map, you can go to the web address that I've shown there on the slide, and it's available there. And you can subscribe to receiving future updates of this map as well. And also our country by country updates on key issues that we've been flagging and things to watch out for under local implementations. Next slide, please. So on this next slide, we can see which countries have implemented NIS2 so far. And these are the countries on the NICE list, which is the left half of the slide. And you can see the countries that are on the naughty list. They haven't implemented NIS2 and they're on the right half of the slide. And the eagle-eyed may have spotted I've included Switzerland here. They're on the NICE list, so they're not actually in the EU, but because they've partially implemented NIS2 already, I've put them on there, and bonus points for Switzerland. Next slide, please. Now, some of the countries on the NICE list have actually only implemented the legislation partly, so that's why you can see them in red, so Denmark and Hungary. And Greece is in red as well because they only just narrowly made it into the NICE list with a very recent implementation. And just as a heads up, we've very recently, in fact today, heard from our best friends in Hungary that in Hungary they're actually planning to change their implementation of the NIS2 law again, so watch out for that one. Next slide, please. Now, we've also heard in recent weeks that the European Commission are wasting no time, and they're actually threatening to instigate action against the countries that are on the naughty list and those that have only partially implemented NIS2. And well, that's possibly why Hungary have decided to make some changes to their NIS2 implementation. And Greece was on the European Commission's naughty list, and that's because at the time of their announcement, they hadn't actually implemented NIS2. Next slide, please. For countries that have implemented, as I mentioned earlier, we're publishing a series of updates and we're flagging the key issues to watch out for in the local implementations. And as I said earlier, you can subscribe to receiving these updates. Next slide, please. Now, we're getting lots of questions from clients who need to prepare. And so I thought it'd be helpful to share with you all a high-level NIS2 preparation roadmap. Now, the priority has been, first off, doing a NIS2 applicability assessment, which is to determine whether NIS2 actually applies. And if it does, after that, the priority has been to help clients with their local registrations. Now, Hungary's been a really busy country for registrations because they didn't implement the main establishment principle, which is sort of like the GDPR one-stop shop. And it means that clients for which Hungary is a relevant country, we've needed to help them register there, even though it may not be their main establishment under NIS2. Actually, let's wait and see whether that gets changed with Hungary's next iteration of NIS2. We're also getting into the weeds with our clients, supporting on security gap analysis. And in particular, we've been helping with mapping of security against the directive itself, but also the one implementing regulation that's been published so far. And this is a set of specific security requirements for digital service providers. We haven't had any for other sectors, but in the absence of guidance, regulations for other sectors, we've been using these as a helpful steer. We're also mapping against the draft ANISA guidance, which has been published. So it's still in draft, but very helpful for interpreting the requirements for digital service providers because it expands on the implementing regulation. What else is on the roadmap? So board briefings, particularly flagging against potential for management liabilities, updating internal governance structures, contract updates, both upstream and downstream. Policy and process reviews need to be on the to-do list as well. NIS2 training, and also updating your incident response processes. Because the NIS2 thresholds and timeframes for notification are different to GDPR. And in case of interest, we did host a webinar on notification requirements under NIS2 and other digital regulation. We compared it against GDPR, and that was in October this year. And you can find that webinar on Fieldfisher's privacy team YouTube channel, along with lots of other great webinars from the team. Now, that was a super fast walk through the NIS2 preparation roadmap, but if anyone would like to talk about preparations for NIS2 in more detail, then please do get in touch.
Thank you very much, Kirsten, and loved the plug for the YouTube channel at the end. Well done, you. So next, we hand over to Thorsten, who is one of our lovely German data privacy lawyers, and he's going to give us a case law update and no doubt some scary stories from Germany. Thorsten, over to you.
Thank you, Hazel. And thank you, everybody, for either tuning in or listening in on this later on YouTube channel, for instance. Next slide, please. My name is Thorsten Nieler, as it said, and I'm a technology and data partner in our Hamburg office in Germany, and often serve as a DPO externally, obviously, for clients. And what I've done here is, as you'll see on the slide, I've tried to identify 3 areas from CGU jurisprudence over the year 2024, where I saw some practical implementations, whether it's for you as part of a privacy and compliance team or in my external DPO role. Next slide, please. The first topic, personal data, sounds innocuous, and maybe you're tired of discussing this internally or externally with your various stakeholders. This is a slide on, I'd say, flavors and preferences, and you'll see why. So we've had the IEB Europe case at the top of this slide, where the TC string and the data therein has been classified as personal data because of the connection, because it's, as it says here, associated with an identifier like the IP address that can trace the data back to individuals, i.e. data subjects. Now, this goes in the direction of the abstract versus concrete view on personal data and how to determine that. It's fairly broad, I'd say. Maybe it's not that surprising, but the point is you'll have to, as a practical implementation, assume that so much involving an ID, some kind of unique identifier, will be classified as personal data that it may not make sense to argue against this, to argue for anonymous data. I'd say nothing new there, but reconfirmation of this fact. On the next bullet here, sorry, not slide, bullet here, sorry, that was confusing. We've had a bit of a, I'd say, surprise, perhaps half a surprise, because what the court has told us here is that maybe context can trigger Article 9, special category data. Why do I say this? Because in this case, Lindner particular, triggered from Germany, the court has held that the data that you have to put in e-commerce shops, in this case related to non-prescription medical products, also qualifies as Article 9 data, not just the prescription, if there is one, or the actual order itself, but also the data connected with it too, for payments and to ship this to you. That wasn't quite clear, which is why it has ended up with the CGU. So we know this now, and my practical implementation, my takeaway is you should have another look at your e-commerce website, shop, maybe your distribution chain, whether you may require more Article 9 consent than you had before. And at the bottom, I won't say too much about this because it's a UK case and I'm just a German and EU lawyer. What I'm taking away is the flavor part about plain vanilla data. I hadn't heard that before. This is quoted here from the Curry's ICO appeal, also from this year, early on in September, where again, the appeal is discussing when something is personal data for which controller. And if you pass on data and you're not able to make the connection with other data and identify the data subject behind it, then this is something expressly called plain vanilla data and does not qualify as personal data, and thus is no longer subject to the data protection regime, as it says here. Now, I don't know whether this is going to help us resolve that age-old dispute of strawberry versus chocolate versus vanilla, but I seem to sense a potential diverging of positions in the UK versus the EU, but let's see about that. And now next slide, please. Well, we're getting a bit into the point of damage, the sense of Article 82 GDPR. So maybe if you look at the yellow highlights I've put in here, damage, fear, and loss of control, there's a theme. that goes through this. There's a couple of minor helpful points. If you're on the defense position, maybe as a platform operator, maybe someone dealing with the outfall of a data breach. But we're seeing fairly consistent jurisprudence here, which has already made its way, at least in Germany, into national courts, is that something like fear or loss of control itself can qualify as damage under Article 82, thus potentially leading to claims for damages being awarded, financial compensation. Then one helpful bit is that, as it says here in the middle of the slide, an infringement of GDPR itself does not suffice. We knew that. But if there is some kind of fear, and this can be proven in court by the data subject and their lawyers, then that can amount to damages. The German case I have at the bottom here says that something on the order of 100 euros in compensation can be sufficient to compensate for that damage. Sounds reassuring, however, as a practical implementation on the right-hand side of the slide here, it can mean that there's potential for mass claims here, where it's just about legal cost actually, because there are business models out there where, let me call them attacker firms or consumer law firms, use dozens, hundreds of cases they rake in to just bring them and claim legal fees, especially where data subjects have insurance for legal disputes. And next slide, please, where the last topic is the undertaking as in Article 83 GDPR to determine the amount of revenue. Just to recall, at the very top here, Article 83, paragraphs 4 and 5, the worldwide annual turnover is what you have to determine as a regulator if you want to know the fine framework. Mind, this is just the maximum fine possible, not the sort of a baseline fine or an indicator of the fine in the end, just the maximum. But still, what we're taking away here, I don't think it's a big surprise. It's just an AG opinion for now. It still has to be decided by the court. And it's citing a lot from Deutsche Wohnen a year ago. Is that competition law, we can use competition law legacy cases from the CGU under Articles 101 and 102 on the Treaty of the Functioning of the Union, where you have to look at the undertaking, legal notion, and then determine some factors and criteria in calculating this maximum fine based on the revenue. On the upside, perhaps a couple of points in the middle here. It's just one relevant element among many others, this undertaking, legal notion, and the revenue, and how to determine the undertaking, whether it's a group of companies. There's a couple of important criteria also on the right-hand side here. Something like who's making the decision. Sounds an awful lot like being a controller in GDPR. What is the relevant processing? Is it limited to just one group entity? Is it group wide? Which group entities have been involved in the processing? Do you have a group processor maybe that's involved in the processing and wide systems? This could drive the revenue and thus the fine framework. And the point at the bottom here is there will, of course, be a strong influence from member state law because this is subject to criminal law. The fine proceedings and how to appeal them in court is subject to criminal law or law about administrative fines, however this works in your jurisdiction. And that will play a heavy influence. A determining factor will be something like proportionality from law of criminal proceedings. And that's it from me. Thank you.
Thank you very much. So now we're back to the UK and we're going to hear from my colleague Renzo on the Data Act. Renzo, please introduce yourself and your topic.
Hello everyone, I'm Renzo, a partner in the London team. So just like Torsten dared to delve into UK case law, I will talk about an EU piece of legislation. Data Act. So the Data Act is on the statute book and actually formally got on the statute book in December 23, but became effective in January this year. And I call this, it isn't just the AI Act, because in my mind, it was going through the legislative process in the EU at the same time as the AI Act, but somewhat under the radar and had very little publicity, but it has got big consequences for a lot of people in an increasingly connected world. So we move on to the next slide. This slide here, which is inspired by an example by the European Commission, setting out its rationale for passing this piece of legislation. And it's all about the Internet of Things and connected devices. So the paradigm illustrated here is of a connected coffee machine. Now, these things do exist, and they do measure water usage, temperature, numbers of coffees made, number of ristrettos or flat whites made. And that data might be collected by the manufacturer that's providing an ongoing connected service in relation to how the coffee machine is performing to the cafe owner. And the cafe owner is the user of the connected device in the terms set out in the legislation. And it's all about a free movement of that data. The European Commission sees a good economic reasons for having good access to the data that's collected in relation to the use of the coffee machine by not only the manufacturer, but also the cafe owner. Now, why would the cafe owner want to know usage and temperature and such things? Well, the reason is that it might be useful for calibrating the machine or servicing the machine. When does the machine need to be serviced, and so on. And the cafe owner is not themselves necessarily going to be servicing the machine, but they're going to be appointing a potentially unauthorized third party, potentially in competition with the manufacturer, in order to service it. So the Act sets out a regime where the cafe owner has an access right in relation to the data, and also a portability right in relation to the data. And the portability being to the servicer in this example. If we can move on to the next slide, please. So the main obligations in relation to the connected device in any online service which is related to it is to allow the user, which is the cafe owner, and importantly here, it will be an enterprise. It isn't just coffee machines, it could be medical devices. The user will be, in the UK, the NHS Trust, or elsewhere, the hospital group, or whatever it might be, that's actually bought the particular devices. So the user of those devices will have a right to get the data out of the device, and there's an obligation, I put it in quotes here because there's a question mark as to how strong that obligation is, to actually design products to allow for ready accessibility to the data. So the question mark arises because the European Commission has tried to explain away the provision in a much more business-friendly manner than the language of the draft would actually suggest. But if you can't make the data readily accessible, then you have to provide the data on request. And that's very similar to, in GDPR terms, an Article 15 request, an access right. As I say, there's a portability right as well in relation to others in the market. So the user, importantly, might not necessarily be an individual, could be a corporate, and the data, think water usage, temperature, and so on, is not necessarily personal data, but could be personal data. So it captures non-personal data as well. So we've been helping clients work through all this over the last few months since the law came in, and begun to produce various deliverables which a lot of companies will want in the connected device space. If you can move on to the next slide, but we've identified about 15 different action points that might be done, and I haven't got time to talk them to all of them, of course. First of all, a Data Act mapping exercise like we might have done for GDPR back in the day. What products and services are in scope? What data is in scope of the request? Now, data that's on the language in scope is data that's generated by use. But if you process that data as the manufacturer to some degree, does that go out of scope? Well, the answer is yes. If a significant investment in the algorithm to process that data it becomes something called derived data. If it's not significant investment, it remains either raw data, the original data, or pre-processed data. So there's going to be a lot of analysis needed around what's in scope and what isn't in scope that might be being collected and then processed by a device or a related service. Nor is data in scope if it's protected by trade secrets. So a lot of analysis around that. Other actions that might be done would be to review contracts, both in terms of documenting the access, documenting the portability, but also, and very similar to similar provisions or discussions that might arise under Article 28, if the service provider, the manufacturer, wants to use data on the device for its own product improvement on R&D purposes, it will now need contractual permission to do so. So contracts will need to be reviewed. And just like for GDPR back in the day, people prepared a nice accountability suite of documents, so access policies and procedures and procurement documentation and so on. A policy suite might be useful for some organizations to have. So yeah, create a project plan and in good time, because most of this stuff comes into force in September 2025. If you move on to the next slide, please. Now, 5 minutes or 6 minutes is, which Hazel gave me, is not really enough to even talk about connected devices, let alone time to talk about another important part of the Act. So I'll just mention it. There were also provisions which will apply to quite a lot, but not all, cloud computing service providers, infrastructure as a service providers, or SaaS providers may well be in scope of a bunch of provisions to do with cloud switching, the ability of a customer of a cloud company to easily switch to a alternative provider of the same or similar service, and you can't put organizational, technical, commercial barriers to a early disentanglement of a particular service procurement. Again, there's exceptions for trade secrets and so on. And the data, again, will include both personal data and non-personal data. I've scratched the surface here. If you want more, we did produce a 1-hour webinar on the topic back in March. That will be available, another plug, on our YouTube channel, or just contact your usual contact at Fieldfisher. And also we produced a white paper and blog, which is available on our website. Hazel, that's it.
Thank you very much, Renzo. Next on scary topic that all lawyers love to talk about. So Kira, my colleague in Ireland, has now got the hotspot of telling us about regulatory fines. Kira, over to you.
Thanks so much, Hazel. Hi, everyone. My name is Kira Burke, and I'm dialing in from Fieldfisher here in Dublin, Ireland. I'm going to provide somewhat of a whistle-stop tour of some of this year's biggest data protection fines in no particular order. And on to the next slide, we're going to start with Meta. This one coming out of Ireland. By way of background, the Data Protection Commission here in Ireland, Meta's lead supervisory authority, launched an inquiry after Meta had notified its office that it had inadvertently stored certain passwords of users in plain text format on its internal systems and without measures such as encryption being in place. Ultimately, the Data Protection Commission found infringements with respect to Article 33 of the GDPR on the basis that Meta had failed to notify the DPC of this breach and had failed to document it. It further found infringements pertaining to Meta's compliance with the data protection principle of integrity and confidentiality, which we all know sits in Article 5.1f, given it did not use appropriate technical and organizational measures to ensure appropriate security of users' passwords against unauthorized processing. On a similar vein, the DPC further found infringements of Article 32 GDPR for failure to implement appropriate technical and organizational measures to ensure a level of security appropriate to the risk. And this ultimately resulted in a reprimand for Meta and an administrative fine totaling €91 million. Staying in Ireland for now, and next slide, please. we're moving on to LinkedIn. So this one has been on, I suppose the desk has been around for a little bit more time, but essentially the Data Protection Commission, being LinkedIn's lead supervisory authority, launched an inquiry on receipt of a complaint made by a French group called Le Quadrature du Net, which is LQDN for short, which was initially submitted to the CNIL, the French Data Protection Authority. At a high level, the inquiry examined LinkedIn's processing of personal data for the purposes of behavioural analysis and targeted advertising of LinkedIn members. Ultimately, the DPC found various findings of infringements with respect to Article 6 of the GDPR, which we all know pertains to the various legal bases for processing, in that it raised various issues with LinkedIn's reliance on consent, on legitimate interests and contractual necessity in different contexts. It further found that LinkedIn had infringed the principle of fairness, but also LinkedIn's issues with LinkedIn's compliance with transparency obligations that can be found in Article 13 and 14, more specifically with respect to the information LinkedIn had provided to data subjects regarding the legal basis being relied upon. The decision ultimately included for LinkedIn a reprimand, an order for LinkedIn to bring its processing into compliance, and 3 administrative fines totaling €310 million. Next slide, please. And hopping across the pond to the Netherlands, here the Dutch Data Protection Authority launched an investigation into Uber after more than 170 French drivers complained to a French human rights interest group, which subsequently submitted the complaint to the CNIL, the French Data Protection Authority. This was then picked up by the Dutch DPA, given Uber does have its European headquarters in the Netherlands. Now, the Dutch DPA found that Uber collected, amongst other things, sensitive information of drivers from Europe, and transferred and retained it on servers in the US. These details, this information included taxi licenses, but also location data, photos, payment details, identity documents, and in some cases, even criminal and medical data of the drivers. Now, for a period of approximately 2 years, Uber transferred this data to Uber's headquarters in the US without using appropriate transfer mechanisms per the GDPR. And this ultimately resulted in the Dutch DPA imposing a fine of €290 million. And last, but certainly not least, we're moving across to Italy. Next slide, please. So here, the Italian Data Protection Authority imposed a fine of over €79 million on Enel Energia, essentially regarding breaches of its obligations relating to telemarketing and data security. Now, the Garante, being Italy's Data Protection Authority, challenged Enel Energia with respect to a lack of compliance with technical and organisational measures aimed at limiting the potential abuses by agencies that had unlawfully performed telemarketing activities. So at a very high level, an investigation by the Garante revealed that Enel Energia's marketing activities were carried out using illicitly acquired lists of customers, which did contain various contact information, including addresses and telephone numbers. In addition, the Garante ascertained that the information systems intended for customer management and the activation of services by the company, something very similar to a CRM system, showed serious security deficiencies. Enel had not put in place all the necessary measures to prevent the illegal activities of abusive agencies who undertook such telemarketing calls. And this resulted in the Garante imposing what was a record-breaking fine for them of €79 million on Enel Energia. And with that, I'm going to hand you back to Hazel.
Thank you very much. Gosh, we are whizzing through the topics, but we are going to slow down a little bit here. We have a double-handed session from my colleagues Leonie and Olivier on AI, everything AI. So I think, Leonie, you're going to kick us off.
Yes, thank you very much, Hazel. Good afternoon, everyone. My name is Leonie Power. I'm a partner in the London Tech and Data team at Fieldfisher. And together with my colleague Olivier, we'll be taking you through some of the practical considerations in relation to implementing an AI strategy. In the first instance, I'm going to introduce you to this concept of an AI governance onion and discuss a roadmap for implementing a robust AI governance framework. I will discuss at a high level an approach to addressing specific regulatory risks that arise under the EU AI Act. And then my colleague Olivier will take you through some of our AI offerings, which are aligned to the AI governance roadmap, and will also point you in the direction of some of our key tools and resources that we've developed. Next slide, please. Okay, so I wanted to introduce you to this concept of an AI governance onion. And as we all know, there's been lots of hype about the EU AI Act, but it's critical to ensure that as an organization, regardless of whether you're subject to the EU AI Act, that the use of AI within your organization is ethical and effective. And that's where the first layer of the onion comes in. And while I will mention the timeline applicable to various obligations under the EU AI Act a bit later, it is important not to peg the development of a robust AI governance structure to those particular timelines for a number of reasons. Firstly, the risks are potentially much broader than non-compliance with the EU AI Act. Secondly, it makes sense to prepare in advance. And thirdly, as I've mentioned, it's important to ensure that as an organization, you are taking an ethical AI approach, regardless of any specific regulatory obligations. So as part of the first layer of the onion, we have suggested a phased approach, which is not aligned with the various applicable dates under the EU AI Act, but rather consists of 3 phases. At a very high level, the first phase involves assembling your team or gathering your troops and setting your AI objectives. And that should align with your business strategy and should ensure that you involve a wide range of stakeholders. And that's to make sure that you're getting a sufficiently multidisciplinary input, particularly in relation to potential risks. As part of the second phase, it's important to map and measure risk. So understand what AI is being used and assess risk in a broad sense. So that might be risks arising by virtue of IP issues, potential damage to reputation if a chatbot goes rogue, potential risks of leakage of confidential information, etc. And then look at implementing policies and processes around that. And finally, as part of the third stage, deploying controls to address those risks. And then if we peel back the onion to the second layer, we can look at the EU AI Act compliance or a broader regulatory compliance. And as part of that, you'd consider specifically whether your AI systems fall within the scope of the EU AI Act and the corresponding obligations that arise. And then, depending on the nature of the AI system and the role of your organization, be it as a provider or a deployer, there may be various obligations. And I've set out a few examples of those potential obligations on the slide. So as a deployer, for example, in certain circumstances, you'll need to carry out a fundamental rights impact assessment. As a provider of a high-risk AI system, you'll need to carry out a conformity assessment. You might need to meet certain transparency obligations if you are deploying technology that creates deep fakes, for example. And of course, across both the blue and the pink layer of the onion, you should be thinking about your vendor risk. And then finally, if we peel back a further layer of the onion, as part of any risk assessment, you need to be thinking about privacy and data protection risk. And as part of this layer, you should be looking as far as possible to leverage existing privacy governance structures. And one requirement that does actually cut across all 3 layers is a requirement in relation to AI literacy. And that involves putting training in place to upskill your workforce from an AI perspective. Next slide, please. So I mentioned the first layer of the onion, so that 3-phased approach to AI governance. And this slide essentially sets out those 3 phases. And you'll see from the color scheme that the 3 phases involve organizational measures, putting in place key documentation, and undertaking various assessments or analysis. So that's represented by the blue and the purple and the pink. So we have phase 1, and I'm not proposing to go through all of these phases in detail, but I'll just mention a few points. So phase 1 at a high level involves assembling the relevant team and establishing a baseline and setting objectives. So it will include things like documenting an AI charter or a set of AI principles, and hence the purple color for a documentation task. Now, as we're all aware, there's a whole myriad of AI ethical principles that have been issued by different organizations and bodies, from the OECD guidelines to the UK AI white paper to the NIST risk management framework. So really, it's about looking at those and tailoring them for your organization by reference to your organizational values. And I mentioned already AI literacy. Again, this is an organizational measure. It's important to implement that early on, particularly given the impending deadline of the 2nd of February 2025 under the EU AI Act with respect to AI literacy requirements. And then as part of phase 1, there should be an initial mapping of risk. So that could involve, for example, some kind of perimeter analysis by reference to the EU AI Act. But as we've mentioned, it's not just about regulatory risk, so you should also be looking at your overall risk position. Phase 2 then is about implementing processes and drilling down to specific risks, which might include, for example, conducting impact assessments on specific use cases and determining what controls should be put in place. And then phase 3 is about deploying those controls. So you might look at adopting appropriate testing protocols for AI systems to track their negative impacts and to track whether they're behaving as you would expect them to behave. So next slide, please. Now, in the interest of time, I'm not going to go into any great detail on these particular dates. It's really just a timeline of the applicability for the various provisions of the EU AI Act. I will mention that the next deadline coming up is the 2nd of February 2025, when the provisions in relation to prohibited AI become applicable, as do the provisions on AI literacy. But you'll see there are other dates in relation to the applicability of the various other obligations under the EU AI Act. Next slide, please. And finally then, I've set out here a 5-step approach to EU AI Act compliance, so that what it would ideally look like. And these steps will obviously sit within your overall AI compliance framework. So it's about firstly understanding the EU AI Act requirements, and that's where the AI literacy piece will come in. And there are specific requirements, as we've mentioned, requiring organizations to implement AI literacy. And then conducting a risk assessment of your AI systems. And my colleague Olivia will talk a little bit more about that. But fundamental to any risk assessment is obviously understanding what AI systems are in use in the first instance. And so it'll be necessary to undertake some kind of mapping. And then implementing the risk measures, ensuring transparency and accountability, which should ideally dovetail with what you're doing from a GDPR perspective with regard to transparency and accountability. And of course, putting in place measures to monitor and audit AI systems on an ongoing basis. So on that note, I'll hand over to my colleague Olivier, who's going to talk in a bit more detail about some of our AI offerings and some of the key resources that we've developed.
Thank you so much, Leonie, and hello to everyone. Welcome to this afternoon webinar. So my name is Olivier Proust. I'm a French qualified lawyer working in our Brussels tech and data team. And so you've heard from Leonie that there's quite a lot that needs to be done in order to comply with the AI Act and for AI compliance in general. So what I've tried to do here is set out some of the key work streams that you might be thinking about. This is by no means meant to be comprehensive. There's certainly a lot more that needs to be done, but this can certainly be a starting point and at least a way for you to think about some of the key actions you need to be taken in the field of AI. So as you've just heard from Leonie, sort of framing the overall project is going to be really important. AI is quite new to everyone. I'm sure there are many privacy professionals and DPOs on this call, and although everyone is upskilling and training on AI, we're not naturally AI experts. So this is a whole new area for us, which means that we need to put in place a new governance framework, but we also need to understand what goes into this governance framework. And so you've seen from the previous slide our sort of proposal on the different steps and how you can prepare to implement a AI governance framework. But I have to say that it's difficult to compare it, or maybe we shouldn't compare it with the GDPR. At times we have clients coming to us and telling us, "Oh, you had helped us with a wonderful GDPR roadmap a few years ago. Why don't we do the same thing for AI? Unfortunately, at least in the EU with the AI Act, the way the law is constructed is quite different from the GDPR, because it doesn't set out a common set of rules and principles that apply to all the entities across all business sectors, but on the contrary takes a much more risk-based approach, which does mean that there is necessarily going to be a lot more tailoring that organizations are going to have to do, and a lot of initial thinking and planning in order to understand how the AI Act is going to apply to your organization, to your business, and to your services. But some of the things that we have been working on already are preparing, for example, roadmaps or project plans where we help our clients to determine the different steps and the key actions that they need to take. The second work stream is obviously policies. Transparency, explainability are some key concepts in the field of AI. Here again, if I compare this to GDPR, it's a little bit different, because GDPR sort of has a general and a single approach to transparency, and we can then easily replicate this throughout our different GDPR policies. Here in the field of AI, when we talk about transparency, this can cover different things, and we have already assisted many of our clients to put in place different kinds of AI policies, whether it's a broad corporate policy, or sometimes they name it an AI code of conduct, which sets out the general rules and principles that apply to the organization, or perhaps they want something that is more in the form of a statement or guidelines that are aimed at explaining to the employees what are the do's and don'ts around the use of AI services and technology, and some of the guidelines that apply to them. And often, these documents, one way or another, are based on the general international ethical AI principles that we currently have, that were adopted by different international organizations, for example. One of the other things as well that we are starting to see is the tailoring of privacy policies in the context where AI technology is being used. And I think we will be seeing this a lot more, whether it's AI used in the employment context or AI used in a customer-facing context, and there are certainly other examples that we could give. So here again, I think there will be different kinds of AI policies, certainly some broad group policies, but also some slightly more tailored privacy policies that integrate some specific AI wording. Now, the next one, which is probably the big piece that Leonie already touched upon, which is assessment. And here, that's probably where there is going to be the bulk of the work. Companies are going to have to do a lot of AI risk assessment, whereas whether it's assessing, broadly speaking, how the AI Act applies to them, or assessing specifically on an AI system or AI model basis, what are the obligations and the requirements under the AI Act that will apply to them. So we have developed a number of different documents and templates, such as AI risk assessments, with often in the form of a questionnaire, that are aimed at helping our clients to assess and understand whether their product or service is an AI system. What is their role as an organization under the AI Act? Are they the developer, or are they the deployer of the AI? In what category does their AI system fall? Is it a prohibited AI system, a high risk, or does it fall under those AI systems that are subject only to transparency requirements? So there's a lot of risk assessment that will need to be carried out. Also, companies have to map their AI systems, a little bit like what they did a few years ago with their data processing systems, and obviously scoping questionnaires to assess how the AI Act applies to them. And here again, if I compare with existing documentation from a GDPR standpoint, we are starting to see also organizations adapt their DPIAs whenever there is a processing activity that integrates an AI system or tool. So here again, there's a possibility to adapt existing DPIAs and to include some specific or bespoke AI-related questions. And then lastly, we anticipate that there is going to be a significant amount of work on contracts, and we are already seeing a lot of that, whether it's reviewing or negotiating contracts with AI vendors, which is far from being a simple task, because often, particularly when we are on the customer side, customers who are purchasing or licensing AI products from large multinationals often find it difficult to access all of the relevant or detailed information around the product. On the developer side, the product terms are sometimes vague or imprecise. So we do see some challenges there, but we are already beginning to develop our own contracts. Also, due diligence questionnaires. Here again, it goes back to something that we are familiar with already under GDPR, the fact that you need to verify and obtain information from your providers. And we are also developing other types of documents, such as playbooks. And then lastly, as a last example of how we can adapt some GDPR documents, if we take the data processing agreement here, we also see companies that are beginning to integrate in their DPAs or are developing, let's say, standalone or bespoke DPAs when used and applied in relation to AI products and services that they are purchasing or licensing. So if we move on to the next slide, here we've provided a list of some of the additional resources that we have produced on AI that is already available to you. It's been mentioned a number of times that all of our webinars are available on our YouTube channel. So all of the webinars that we have run throughout this year on the EU AI Act, you can find them all on our YouTube channel. And please note our final AI webinar, we will run it on the 12th of December. You can also go on our data and privacy webpage, and here we have gathered and collated in a nice document all of the regulatory guidance from data protection authorities in all of the EU member states on AI. That's obviously a document that we will need to update at some point, but you can already download it from our data and privacy webpage. More recently, this entire group who is providing you with this webinar has collaboratively worked in collaboration with OneTrust Data Guidance on a series of AI notes that is available on the data guidance platform, and that drills into more detail into various aspects of the EU AI Act. And then obviously you can go on our Insights webpage, and there you will find regular information and articles that are published on EU and UK digital legislation, and more specifically on the AI Act as well. And if I move on to the next slide, please. So this is also just to mention in terms of legal tech products that we are developing. I'm sure some of you already know that we have a data breach and compliance manager platform that is supported by one of our external platform providers, where we already make available a certain number of modules for data and systems mapping, also for assessing your incidents and helping you with reporting obligations, TIAs, the transfer impact assessments, and also DPIAs. And I mention this because as part of this data breach and compliance manager platform, we are in the process of developing a new module around AI risk assessment. So I've mentioned here that it's still in construction, but we are hoping that very soon, in the first quarter of 2025, this new model will be available on our platform and should help you to carry out a risk assessments in a much more streamlined and efficient manner. So with that, that covers what I had to say on AI, and I will hand it back to Hazel. Thank you very much.
Thank you very much, Olivier. So our final speaker, last but very much not least, is Carlos, who comes from our Spanish office, who is going to take us through a quick guide to EDPB guidance, and probably, I'm guessing, a Monty Python joke as well, because he's a specialist on that too. So Carlos, over to you.
Thank you very much, Hazel. Maybe not time to joke now talking about EDP, European Data Protection Board guidance. So hello everyone, this is Carlos Perez talking to you from Barcelona. and head of the Tech and Data Fieldfisher practice in Spain. So for the European Data Protection Board guidance, we have chosen those who may have a real impact on businesses and organizations. And if we move to the next slide, we will talk about the first one, which is related on the guidelines that were published by the European Data Protection Board on tracking technologies. So as I'm sure you are all aware of, the European regulator wanted to leverage the protection of confidentiality in electronic communications via the approval of the privacy regulation, but that the regulation was not approved and is living with angels. So how has the European Data Protection Board leveraged the protection? So it has gone to the existing regulation, which is the privacy directive, and has provided a broader interpretation of the article that is governing the use of tracking technology. So according to this interpretation, which I will explain now briefly, basically what the European Data Protection Board has come with a level of protection which is similar to what happened with the cookies. So if you remember, cookies are not subject to consent if they're used for technical purposes, which means that they're needed to transmit the information or to serve the information society services requested by the subscriber. But other than that, any other use of these techniques will be subjected to consent. So this equivalency has gone by broadening the interpretation of the Article 5.3 of the Privacy Directive, making clear that this is applying to any type of information which is in the hands of the subscriber and in the devices that are handled by the subscriber, not just personal data, but any kind of information, and making clear that terminal equipment is any kind of device that can be connected to the network. Also clarifying that a public communication network, as described in this article, is any type of infrastructure that allows to exchange information by electronic means, and also has given a broader interpretation of the concepts of gaining access and storing information. So making clear that it applies not just to individuals, but also to legal persons that are storing information in their terminals, and that the application of this article goes both to gaining access to information and storing information. So if we go to the next slide, these guidelines is analyzing specific use cases where this article and this broadening interpretation applies. So very quickly, just giving an overview, for instance, it analyzes the use of URL or pixel tracking, which applies to there are techniques that can be connected to tracking links or tracking pixels, which might lead to track the user's behavior. So in this specific situation, the European Data Protection Board understands that use of these techniques implies gaining access to information which is in the subscriber terminal. So this means that this article will apply in using this technique will require prior consent of the subscriber, if not used just for technical purposes. Very similar to the local processing. So if there is coding developed, for instance, via interfaces, application interfaces, the retrieval of information by the entity which is developing the client-side code will also imply gaining access to information stored. So if you're using this technique to gain information on the subscriber terminal, again, it will require consent if not done for technical purposes. The same in the case of IP-based tracking, this will only apply, or this requirement of consent will only apply if the information that is obtained, it's originated from the subscriber terminal. If the IP address is obtained from other sources, that will not apply. But if obtained or the information comes from the terminal, again, it will require consent, or it should be justified for technical purposes. And the same for information which is generated from the Internet of Things reporting, which means information which is retrieved from household devices, or the unique identifiers that are included in general in subscribers and users devices. So what is the practical outcome for the organizations on this? Well, if not done yet, it will require to reassess the use of these tracking technologies, for instance, to measure the effectiveness of our marketing campaigns, and especially if the measurement of these and of the efficiency of these marketing campaigns is provided by external providers or service providers, which might be using these techniques without not being fully aware of, which are subject to the consent of the for instance, the client that might be tracked, and that would be might be posing us in the risk of breaching the regulation if the consent has not been obtained from our clients in using these tracking techniques. So be careful, and we will. It will be advisable just to reassess if we're using these techniques, or be careful if any of our external providers is using them in helping us to measure this efficiency. And going to the next slide, I mean, talking about external providers, this leads us to the second guidance we wanted to highlight. This is not coming from a guideline. This is coming from an opinion that, as I'm sure you are also aware of, the European Data Protection Board is also entitled just to produce these opinions to harmonize the interpretation of articles in the GDPR if requested by the national data protection authorities, which is the case. The Danish Data Protection Authority addressed to the European Data Protection Board to unify the interpretation of several things related with the obligations of due diligence of data controllers in relation with the value chain and with the relation of the chain of processors and sub-processors. And the outcome of this, it might be quite burdensome, because if we bring this opinion to the very letter, the importance of the due diligence and the impact of the due diligence for the data controller is really broad. So, for instance, to the question addressed by the Danish Data Protection Authority in the sense of, is the data controller obliged to identify every single one of the sub-processors in the chain? The European Data Protection Board here says that the information of all the chain of sub-processors should be easily accessible and readily available, which means that it doesn't mean that you have to identify it every single time, but it must be accessible at any given moment, specifically in the moment of an inspection. So this can be an obligation which can be quite burdensome. The same one goes for the verification of all the processing chain. Here, the European Data Protection Controller says that the ultimate responsibility to verify if a processor or a sub-processor is in a position to comply with the regulation relies on the data controller, which means that this again is increasing the due diligence obligation. The third, on the obligation to verify the very existence of the agreement signed between the main processor and the subsequent processors. Here, the European Data Protection Board has not been demanding. It says that it's not necessarily on a systematic way, but it will depend on a case-by-case basis. And if the risk analysis so recommends, in that situations, then it will be necessary just to also to verify if there is an agreement also signed between the main processor and the sub-processors. And finally, on the onward transfers, again, if in the chain of sub-processing there is an international transfer of data, the compliance with the conditions established by the GDPR, again, and the ultimate responsibility relies on the data controller. So this means that, again, the data controller will have to verify if there is any risk of international transfer of data and not complying with the European standard for that. Finally, on if the data processor is entitled just to process data, if obliged by European or national or member state legal requirement, it can be done with no need to express it in the agreement, but at least the data controller must be informed that this is happening. So what is the practical outcome of this opinion issued by the European Data Protection Board? Is that maybe we'll need to reassess what is our process of the onboarding and auditing of all our chain of processors and sub-processors, just to make sure that we are complying with these requirements. The positive outcome here is that this can make easier just to include much stronger provisions and obligations in the data processing agreements with our main processors and with our sub-processors, because we can ensure that we can make it easier to ensure that we comply with these obligations by asking or by requiring the main processor and the sub-processor just to be obliged to comply with this. And if the main processor or the sub-processor is not accepting these terms, then this opinion is backing us up and saying, look, and if we are not doing this, both of us, we are in a potential risk of breaching the GDPR with the corresponding risk of being fined. And we have seen, at least here in Spain, in my country, case law with very heavy fines on data controllers, but not properly assessing the processing and sub-processing chain values. So this is there are real examples where this is a real risk. Last but not least, if we move to the next slide, we would go with what is not published yet. We would go with a guideline which is still in the oven, which is in the process of baking yet, and it is related to the guidelines on legitimate interest. And this is still in the draft status, and the consultations period has been recently closed. So what is the practical outcome here? Is that again we have seen case law again in Spain, where organizations have been also heavily fined, but not applying correctly the legitimate grounds of processing of data. And one of the important one is the legitimate interest. So this means that if our organization is relying on legitimate interest for the processing of data, then we'll have to justify it properly, and then we have to document it properly. So in this legitimate interest guidelines, and just to explain it very briefly and give an overview, basically what the European Data Protection Board is recommending a three-step approach in order just to have a proper justification of the correct application of the legitimate interest. And this three-step approach would have the following steps. First one is to analyze the legitimate interest pursuit. It has to be assessed. It can be done for the legitimate interest of the main data controller or of a third party, and it will have to analyze what is the if the legitimate interest must be justified in the terms of being lawful and being necessary. That which goes to the second step on the assessment, which is the necessity of the processing. Here, the European Data Protection Board in the draft of the guidance says that it must be clear that if there is an alternative way and less intrusive way to achieve the purpose of the processing, then necessity is not justified. So if there's an alternative way, then legitimate interest will not apply, and this is quite linked with the data minimization principle. And the third one is that it's just doing the exercise on the balance between the legitimate interest and the rights of the data subjects by analyzing all data subjects' rights and freedoms which are at stake, which might not be limited to data privacy. It can apply to other rights and freedoms. Second, what is the impact on the data subjects, depending on the analyzing the nature of the data, the content of the processing, what is the further consequences that the processing might have, and analyzing the context of obtaining data, etc., etc. And third one, analyzing the data subjects' reasonable expectations from the processing of data that is carried by the data controller. Is as a result of these three-step approach, it can be really documented and justified that the legitimate interest is not overridden by the rights and the freedoms of the data subjects, then we can go ahead. But if not, then the European Data Protection Guidance indicates that corrective and preventive measures might be applied. But after the application of these mitigating measures, then the legitimate interest will have to need to be reassessed, just to make sure if, again, the legitimate interest with these corrective measures really overrides the rights and the freedoms of the data subjects. Then in these guidelines, there is a quick analysis on the relationship between legitimate interest and the data subjects' rights. Mainly, the main ones are just here the European Data Protection Board highlights that legitimate interest is always linked to obviously the right to object. And if the data subject is objecting, is really exercising the right to object on the purpose, on the processing, the data controller will only be allowed to keep processing if there is a justified and compelling reason just to go on with the processing. Otherwise, it will have to be stopped. This is very similar to the erasure right, and there is also an analysis on the rest of the data subject rights, but has lesser implications. Finally, the legitimate interest guidelines, they go to an analysis on several specific scenarios, where I won't go into detail in this because it would need much more than 6 minutes just to analyze it. But there is a specific analysis on legitimate interest for the purposes of processing of children data, for the processing of data by public authorities, fraud prevention, direct marketing, groups of undertakings, information system security, and transfer of data to the authorities. In these scenarios, mainly the European Data Privacy Board indicate that legitimate interest could apply, But again, that this approach and this balancing exercise has to be done successfully and analyzes specifics and provide insights on specific situations for these kind of scenarios. So with this, and just to finish and to summarize, this again will generate the need of reassessing the process of how do we justify and how we document the application of the legitimate interest in the processings of our organizations, which we understand that can be justified by legitimate interest. So with this, over back to you again, Hazel.
Thank you very much, Carlos. So we are very nearly at time, and I did say to you that we would finish early. So, and there you have it. The clock has just gone round to 5:15. So I think we're going to have to reply to questions by email. Thank you so much for attending, and thank you for the questions. Thank you to my speakers for a very clear summary of what's been bothering data privacy lawyers over the past year and what's likely to bother them in the coming year. We are going to send you a copy of the recording and the slide deck. Please do visit us on YouTube, subscribe to our blog, and I think it just remains for me to wish you all the very best for the holiday period to you and yours. Thank you very much.